In session 2 of chapter 11, let's have a look at some important clauses as well as the flow chart for the integrity pact bank guarantee. There's certain important clauses in the post-contract management. The first one of them is the pre-dispatch inspection or the PDI and the joint receipt inspection of the JRI. As the acronym or the name suggests, the pre-dispatch inspection is normally done in the vendor's premises, in which before the dispatch, the equipment, the order is inspected, and joint inspector at the receiving station. It is jointly done both by the vendor as well as the buyer, and it is certain that the equipment has been received in the correct amount and the correct quality. All this is done as per the acceptance trial procedure, which is finalized during the contract, the ATP. Now it has to be laid down in the ATP. The procedure is in detail laid down. Both the inspections go as per the ATP. Now the cost in case of the PDI, it is done by the cost is borne by the seller. In case of the JRI, it is borne by the buyer. The PDI could also be conducted abroad when you are in a buy global case. In this case, the approval of the team is by the vice chief, but the government sanction letter is given by the MOD. And in this case, the seller has to inform the buyer that this would be the likely date of the equipment being dispatched at least 45 days in advance or as laid down in the contractual schedule. Whenever it's an Indian seller or the PDI is in India, the seller informed the buyer and the quality assurance agency at least 2 weeks prior to the dispatch or as per the schedule that has been agreed to. Now, at times what happens both in abroad as well as possibly in India also, the buyer is unable to attend the PDI, maybe because of many reasons. Now, the payment is not withheld. The payment is released on the PDI carried out by the seller. That is, before dispatch, he carries out his PDI using his own quality assurance, etc. And he renders a certificate and the payment is released. The documents are submitted and the payment is released. However, on receipt of it, during the JRI, essential tests are done to ascertain what the correctness of the certification that has been done by the buyer before dispatching the equipment. If there is a delay in intimation by the seller and it results in delay to the delivery, applicable liquidated damages are imposed by the seller on the buyer. There is a provision of reverse LD also. We'll talk about it later. Joint receipt inspection. Aspects which are inspected during the PDI are normally not inspected during the JRI unless it's considered necessary. What is basically to ascertain that nothing has gone wrong during the dispatch and during the transportation of the equipment, and the equipment is the same. Obviously, where the PDI has not been held, not been where the buyer is not present for the PDI, the JRI would have to be much more in detail. All defects, discrepancies, notice will be rectified by the seller within the stipulated contractual period. If the item fails, the seller has to replace within the delivery period. If he does not do so, liquidated damages will be imposed. Re-JRI can be ordered at seller's cost if consignment is not as per the specification or the quality. So re-GRI, and however here where the GRI is being paid by the buyer, now it has to be for the re-GRI, it has to be by the seller. Now packaging during the contractual stages is very specifically laid down as to what the packages would be, what would be its contents, what would be the breakdown, etc. The stores are required to be packed as per the contractual provision. In case it is not done, the PWBG is withheld till the time the quality agency inspects the items and certifies that the deviation to the packaging has not caused adverse effect on the consignment. Other clauses, firstly, is the change in name of vendor. At times it happens while the contract is going on, the vendor's name is changed because of whatever reasons that are there. So the procedure for this is that it can take place at any stage of procurement. It could be during the pre-contract stage, the contract has not been signed, but the trials is on, or whatever procedures of TC, etc. is on, or it could be during the post-contract once the contract is signed. Now, important to note is the procurement process does not stop once a letter is received that the vendor's name is changed. Now, there's a chain for approval that is required over there, which is internal to the MOD. And the approval of this is communicated to the vendor within 3 months of submission of the complete document. So it is ascertained by everybody, including the industry of chambers of commerce, and after approval, it is communicated to him within 3 months. Now, there could be the possible that the vendor has multiple cases going on simultaneously. Now, in this case, each case would not have a different case. Only a single case would be processed, including the details of the cases that he's involved with, and a common approval is taken for all cases in change of name of vendor. And acquisition wing is responsible for informing all organizations of the MOD regarding the change in name. Now, end user certificate is given by the buyer to the seller, and this is done within 30 days of signing of contract. It's quite important, especially when we have contractual provisions with US, with with foreign countries, and it should be rendered by one-star officer in the SHQ, and it is applicable. The one-star officer is applicable both for the delegated as well as the non-delegated cases. Now, we spoke about the buyer furnished equipment in previous lectures that I've taken. Buyer furnished equipment is nothing but there are certain equipment which, due to the commonality, components or assemblies or something, because of commonality of the equipment, the SHQ imposes on the seller that you will take this equipment only and provide it. It shall be part of the complete system that you are providing. And if the BFE is already available with the buyer, however, it becomes unavailable, oblique delayed in provision. Now, at times, what happens like DPSUs oblique OFP has to provide the buyer furnished equipment. The vendor is told, he may be a private vendor, that you please take this from the DPSUs oblique the OFP. Now, at times it gets delayed. The fault is actually of the OFP oblique the DPSU, which or of a private vendor also, which has been earmarked for provision of this to the main vendor which is contracted. So the BFE, which is earmarked not later than the conclusion of contract. So previously it has already been earmarked. There's sufficient time, and the plan is worked out to make it available to the seller in time for it to provision the complete equipment with the buyer furnished equipment also included into it. In case that it is a delay, the SHQ informs the MOD as to what impact it will have on the delivery timelines. And a delay is notified to the seller at least 60 days before scheduled time. This is basically for his to orchestrate his assembly line so that is not affected. And delivery schedules of the supplier are accordingly extended. Now, a clause comes in this. A few years back, reverse LD was allowed. That is because of the delay. There has been problem in the delivery schedule of the complete thing. The assembly lines of the seller has been affected because of no fault of his. It has costed him money. So because of this, there would be reverse LD that would be imposed on the MOD, which would taken from either the DPSUs or OFPs, etc. And if it is from a private vendor, if the BFE is to be procured by the buyer from another vendor, then a status report and timelines for procurement of the BFE will be mentioned while obtaining the CFA approval of the contract with the seller. That this is what the timelines are and this is what the provisions are. And while the seller of the main contract gets extension in timelines for delivery, the seller of the BNE contract is penalized with contractual obligations. And the seller, based on what the requirement, the main seller, based on what is the requirement, would get a reverse LD in terms of the damage that has been caused to him. The integrity back guarantee is an important document in the whole process. It's a complex procedure. It applies to all the bank guarantees also. So let's have a look at the complete flow as to how this document can be handled. It applies to all bank guarantees because if the bank guarantees lapse or not correctly handled, it can lead to major financial problems. So the integrity back bank guarantee is submitted for procurements only above 20 crore. It's not applicable for below that. The integrity pact bank guarantee as well as the document that is the pre-contract integrity pact along with the commercial and the technical proposal, is sent to the ADG acquisition oblique the SHQ. So it is along with that, when the initial stage, the response to the RFP takes place, at that time, these two documents, the bank guarantee as well as the document for the integrity pact, is sent across. And the DPSUs and OFBs, if ab initio single vendor, are not required to submit. But if they are in the process of a multi-vendor, that is in a competitive case, they are required to give it. Now, the technical offer opening committee is what that examines the integrity pact guarantee as well as the pre-contract integrity pact. And it is forwarded it after the examination for its correctness. It is forwarded to the concerned acquisition manager oblique the SHQ for approval oblique corrections. The TOC has the requisite person from the IFA to be able to examine it. The integrity pact bank guarantee is valid for a period of 3 years. It may be from any Indian public or private scheduled commercial bank notified by the RBI, or even a first-class bank of international repute. It's safe custody. For the safe custody, post the technical offer opening committee, it is sent to the SHQ oblique the acquisition wing based on whether it is a delegated power oblique a non-delegated power by the ADG acquisition technical for safe custody and monitoring of extension requirement. So their responsibility it becomes. For the monitoring purposes, the contract executing officer in the SHQ is responsible to ensure that the IPBG is validated whenever the period gets over or about to get over. Formal request for extension of BG is sent to the bank 1 month prior to the expiry date. And a double banking system for the monitoring of the bank guarantee is maintained both at the acquisition wing as well as the SHQ. And there is a register which is maintained and it is reviewed every 1 month so that a lapse does not take place. For the return of the IPBG of the bank guarantee, if it is post-contract, let's get to the pre-contract. At the pre-contract stage, the vendor which has withdrawn oblique declared non-compliant, that is, he decided withdrawn or declared non-compliant during the process of the complete process, the IPBG is returned by the acquisition manager oblique the SHQ on a non-delegated delegated path between 4 to 6 weeks, and the intimation to this is sent to the ADG acquisition technical. The proviso is there that it will be returned only if the vendor certification of no complaints. When the L1 has been declared, all vendors which are not L1 have reached the CNC stage. They are free to withdraw their IPBG. However, their attention is drawn to the stipulation that should the L1 not go through with the contract signing, the L2 will be invited. So normally vendors do not, especially the L2 vendor does not withdraw his IPBG till the time the contract has not been signed with the successful L1. In post-contract issues, the successful bidder, the validity of the IPBG is extended up to the satisfactory completion of the contract. There could be a situation where the contract price is different to the quote based on the negotiations, and therefore there would be a requirement of fresh IPBGs to be submitted after the contract has been signed. Thank you very much for a patient listening. In the next session, that is session 3 of chapter 11, we will have a look at certain very important clauses and as well as the penalty clauses.